My name is Doug Rosenthal. I'm an antitrust lawyer in Washington, D.C., here today with Eleanor Fox. Eleanor is the Derenberg Professor of Trade Regulation at New York University Law School. She's a member of one of the handful of great faculties, greatest faculties in law in the United States. She has been a leader in antitrust for more than 30 years, and I am proud to have been her friend throughout. Good afternoon, Eleanor.
Good afternoon, Doug, and thank you.
Please tell us about your early years.
Well, let me start at the beginning. I was born in Trenton, New Jersey in 1936. My parents came from Eastern European Jewish stock from Russia and Romania. My mother lived for a long time on the Lower East Side in New York. Eventually, my parents met in Trenton, New Jersey, and I grew up there with my sister Barbara. There were many years before I thought I would become a lawyer. My father was in World War II and was in Missouri. We were in Missouri for a couple of years. I was thinking, as I was reminiscing in connection with this event, what was the first time that I felt real outrage. And the first time that I remember feeling real outrage was when my sister and I were going to school every day. I was 8 years old in Rolla, Missouri, and we had to walk through a lot to get to the school. And every day we would see the little black children not allowed to go to school, not allowed to go to our school, walking to a house where there was a woman who had agreed to teach them. That was my first memory of outrage and maybe the beginnings of my interest, in law and civil liberties and human rights. And although I didn't become a civil rights lawyer or a human rights lawyer in a way, as I will reflect, antitrust in the 1960s was a kind of civil rights for empowerment, and I always felt that link.
Say a little more about that, please. How do you make that connection?
All right, I'm jumping ahead now.
Don't worry about it, Will.
After law school. And I got a job, first a file searching job in a big law firm, Simpson, Thacher, and Bartlett. I was very happy to get a file searching job because they were not hiring women. Firms were not hiring women because women were thought to take the place of men, and men had to have jobs, and women would get married and leave, and women wouldn't stay. So I was happy to have this job. I finished the file searching job, and then they did hire me full time. And then I did become an antitrust lawyer. I had a number of cases. Many of my cases were about smaller firms suing bigger firms with power. The law itself, the antitrust law in the 1960s, was about power, economic and political power. And the law was for diversity. Some 10 years before, with the Selleck-Kefauver Amendment, the merger law was strengthened to prevent more industrial concentration, with the hope that a Hitler would never control the United States. So we wanted economic diversity and pluralism. And our law then was an empowering law. It was intended to break down barriers to people who did not have power.
People still remembered the influence of Louis Brandeis in the law.
People did then. And he is one of my heroes, but he's seldom mentioned today.
That's interesting. You then were married and had children. Tell us about your wonderful children.
Right. I have 3 children. They are indeed all wonderful, all very special, all very different, but all bright and sparkling and creative. My oldest son is Doug. Doug is a computer expert and an entrepreneur who does consulting and creative work with dance, movement, and animation.
Terrific.
And wonderful work. And Randy is my youngest, and he is a lawyer working for New York State in fraud Medicaid department.
He'll be busy.
He's very busy, And my daughter Margot, who is in the middle, who is teaching kindergarten, and she's a musician, writes songs, does gigs for little kids, plays and makes CDs for little children who love her and dance to her music.
That's terrific.
And I have 5 grandchildren who are fantastic also.
I have no doubt. When you graduated from college, you say that a sense of injustice was very important in your becoming a lawyer. Did you think of any other options, or did you know that you wanted to go to law school?
I did not know I wanted to go to law school. I wanted to be a writer. I wanted to be perhaps a novelist. And when I graduated from law school, I did work for some publishing companies. I then became uncertain about whether I could live such an unstructured life as a novelist, and thought I wanted to do something that was more structured. Well, certainly the law is. I knew there was great intellectual interest and excitement in the law, and that there was much one could do as a lawyer, both intellectually problem-solving as well as perhaps some causes. So I went to law school, a very silly thing for somebody to do who really wanted to be a novelist, but it turned out a very wonderful thing as it happened.
Scott Turow wouldn't agree with you, but...
Yes, well, that's true. But in any event, I was so happily amazed and delighted by being a lawyer. When I got out of law school, I was then pregnant with Douglas and worked for some teachers at law school. And I then looked for a job and was told they weren't hiring women, and then got the job at Simpson Thacher, for which I was very happy. And then I spent half of my career at Simpson Thacher and Bartlett with a wonderful group of lawyers doing wonderful work. In addition to the cases I mentioned, I did a lot of work on mergers and merger review. It was a very different antitrust world at the time. There was no Hart-Scott-Rodino. The cases went to court. There was no bureaucracy of antitrust mergers. So I vetted and analyzed hundreds of mergers for Charlie Bludhorn of G&W, and also for Lehman Brothers, for investors looking to see what were the risks that a merger would or would not go through. And I found that extremely interesting because, as all antitrust lawyers know, it is fascinating to get involved in almost any market and learn the dynamics, the facts, and how it works. So on the one hand, I loved my work in analyzing and learning. And on the other hand, I also loved my work when it happened that the case coincided with some of my deeper inclinations in some of the antitrust cases in the 1960s. And I also had other cases, like wrote an amicus brief in Griswold against Connecticut, the birth control case. My senior partner and mentor was Whitney North Seymour, who was a past president of the American Bar Association. He was very much in demand and a wonderful Supreme Court advocate. Many people came to him for arguing before the Supreme Court, or sometimes as amicus before the Supreme Court. So in Griswold against Connecticut, it was the birth control case. Connecticut did not allow the sale of condoms or even advice by doctors about giving birth control. And we represented 99 doctors who claimed that their freedom of expression was impaired by the Connecticut law. And of course, our side won, fortunately.
Indeed. You became the first woman partner at Simpson Thacher in 1970, and if I recall, you were only one of 3 women who were partners at New York law firms. What did that mean to you?
Yes. First, I would say at the biggest New York
yes.
Wall Street type law firms, Amalia Kearse was one of the others.
Now a judge.
And yes,
Second Circuit.
judge of the Second Circuit. Well, it was very wonderful to me, although at that time I was very malleable and fit in very well with the male structure and did not question the fact that it was very hard for women to advance. So I took it in my stride, and I thought it was wonderful, and I was so happy to be a partner with all these wonderful people. But I didn't yet get my feminist consciousness. That came very quickly after, however, because the women's movement started and began to be very strong in the very late 1960s. So maybe my consciousness was a little delayed, but it was just in that period of time. It was the civil rights time, and it was the time when Gloria Steinem made so many things clear that we had denied and had been hidden from us. So I did then become a feminist with a pretty small f, but still a strong consciousness.
Do you think women lawyers who have followed you appreciate the extent to which you broke paths for them?
Well, many say that they do appreciate it. Life is very different today. It's much more equal today. It's not totally equal, but much more nearly equal.
In your years as a practitioner, were there, besides Whitney North Seymour, other role models who had special significance for you?
Yes, I had several that had very special significance. One was Judge Edward Weinfeld, who was the chairman of the board of directors of my law school. And he was a wonderful trial judge. He really believed in the people, he really believed in his juries, and he really believed in his cases and the facts of the case. And I often think of Judge Weinfeld and Whitney North Seymour as two of my great role models who represented quite different things in life, sometimes polar opposites, except that they shared a deep sense of ethics and morality and always striving for the best. So I drew from that. Also among my very favorite people was Betty Bach, who was a wonderful antitrust economist who many people will remember, and I hope will forever, who was an extraordinary human being, extremely modest, extremely bright, did some of the path-breaking work on evidence, economics, economic facts, data, wrote these brilliant articles, often about data, way before her time, and was a very straightforward person, in a way, an innocent in a very complex world.
Brilliant woman. During the last decade, many antitrust specialists have said that until Ronald Reagan became president, antitrust law was in important ways broken, and its enforcement by the Warren Court actually undermined vigorous competition and economic growth. Do you agree with that?
No. And it is very much said, it is true, it is very much said, it is a myth. First of all, it did not undermine competition. The biggest claim is that it handicapped firms in their efficiency and therefore undermined growth. I don't believe that either, but I don't believe it in its strong sense either. But there was a sense in which it was true. Because antitrust law was against power, it also had a bias against a very large firm competing in a market of small firms. And there were principles that were developed that did handicap firms in their efficiencies. That could have been cured without an antitrust revolution that we had. It could have been cured by limiting principles. You will remember it was about that time that Chicago School got a very strong footing. And Chicago School was very important, and still is. One of the most important questions that Chicago School people made us ask was, what is this conduct about? What is it for? Is the firm engaging in this conduct doing something to serve the market and serve the people? We weren't asking that question in the 1960s. We were asking the question, is the market now too concentrated? Is the power exercised to exclude other firms? I wish that that was the question that we focused on and used as a limiting principle. because so much of what went before 1980 and the Reagan Revolution was very good and very important and preserved a kind of dynamic and well-being of competition with a really strong look at entry, access, people being able to contest markets and not be fenced out by power. We're going to have to remember that and draw from that today, because today U.S. antitrust is broken. We've gone so far in the direction of freedom for even the dominant firm that our law is protecting dominance.
What you say is provocative, but I'd like to turn us back a little more to your career, and we'll come back to that subject later. An important antitrust case in the 1970s, this pre-Reagan period, was Goldfarb versus Virginia State Bar. At that time, you were chair of the very prestigious, the Antitrust Committee of the very prestigious Bar Association of the City of New York, and had some involvement. What was your involvement, and what was the case about?
Yes, this was a case about a minimum fee schedule for the Virginia State Bar. And Virginia Bar was sued by Goldfarb, who wanted to buy a house and found that all of the lawyers' fees for closing were exactly the same. And he had done all the work, all the paperwork about the house, the closing fees, the closing effort, time and work was going to be really minimal, and he couldn't get another price. So he suspected
Even though he was a lawyer himself.
Even though he was a lawyer, right. So he brought, and he couldn't get a lower price because it was unethical under the Virginia Bar rules, minimum fee schedule. That case went up to the Supreme Court. At that time, you will remember that lawyers were thought to be not subject to the antitrust law, and lawyers were often thought to be gentlemen who shouldn't compete against one another and shouldn't take one another's clients away. That was very ingrained in the psyche of many lawyers, especially big firm lawyers. So when the case came up to the Supreme Court, the D.C. Bar was already looking at the issue. Jerry Hochberg was the chair of the D.C. Bar Antitrust Committee and told me that his bar association was writing a brief on behalf of Goldfarb, and virtually the whole world of lawyers were writing briefs against Goldfarb. He asked if the city bar would look into it, and I did with my committee, and we all agreed that lawyers should be subject to the antitrust laws and that lawyers' minimum price fixing ought to be illegal. And we wrote a brief. Cy Vance, who was also my partner, was then the president of the New York City Bar, and he and the executive committee approved our brief. Whitney North Seymour, my other wonderful partner, thought that lawyers advertising was going, and bringing lawyers advertising, was a later issue, but part of it. He thought that bringing the lawyers subject to the antitrust law was going to promote commercialization of lawyers, and that the profession would never be the same, and that it was a wedge in the door, with lawyers advertising coming next, that was going to destroy the dignity of the bar. So there was a very serious debate about this. We filed our brief on behalf of Goldfarb, and as I said, many bar associations filed against, and we won.
In 1976, you joined the NYU law faculty. Why did you make the change from being a Wall Street partner, and did you know that you would love to teach?
Interesting questions. I began to think of what else I wanted to do. This is a very personal decision. I know many people make the other decision, and it's much more likely that a person would stay with the firm enjoying the practice as I did. I felt there was something more for me in life. I began to feel that maybe I was protecting balance sheets of my clients rather than setting my own agenda. And I wanted to set my own agenda. I also love students. I knew I loved students, and I wanted to be part of an academic institution. I always loved writing, and I wanted the chance to think more about what I wanted to write. So I joined the faculty of New York University, which is also my alma mater, the law school, and I've had wonderful years at NYU since then. Things have changed. We now have a global law school effort bringing many people from around the world, both as faculty and students, many wonderful interactions, many wonderful faculty workshops, time to write, time to lecture.
In the late 1970s, after you were established in academia, you were involved in two groups that considered antitrust reform. One was the Munich group. The other was President Carter's Antitrust Commission. Can you tell us about those law reform efforts?
Yes. The Carter Commission came first. It came in the wake of the IBM, the big IBM antitrust case and the big AT&T case, and there was concern that monopoly antitrust cases were too big to try. And so the first part of it was about how to harness the big case. And the second part was about regulation and deregulation. So there were several other issues, and some of which we got some legislation on, but those were the big issues. And on those big issues, on the too big to try case, we had many recommendations about case management. And on the deregulation side, we wrote, I think, a really good report on eliminating exemptions from antitrust, much of which is, unfortunately, still has to be echoed by the Antitrust Modernization Commission that just sat a couple of years ago. John Chenefield was the chair of the commission. He ran wonderful proceedings and hearings and debates. In our deregulatory effort, we adopted the, quote, Chenefield principle that when markets with antitrust can work, you don't need or want regulation. Exemptions should be an exception, a very narrow exception to the rule. And when you need regulation, you still see how well antitrust can work within the regulatory scheme and only regulate to the extent absolutely possible. It's a great principle. It's hard to get political consensus to follow it. Then you also asked about the Munich group.
Yes.
That was quite different. It was a small group convened by Wolfgang Fickenscher in Munich. He was at Max Planck and the University of Munich. And at this time of the Munich group, there had been already much globalization. It was already the case, the Berlin Wall had fallen. Many countries were adopting antitrust law. They were first adopting democracy and markets, and with markets they were adopting antitrust law. And he wanted this group to think about some coherence in the system of antitrust and trade and antitrust. And the group, which was mostly German, Japanese, Polish, people from Swiss, people from all over the world, and yet a pretty small group, Larry Sullivan and I were the only Americans. The group came to a conclusion that there should be more or less an antitrust code for the world. It was more flexible than you would think of when you think of codes, because it was basically based on the idea that there would be national enforcement in the shadow of some generalized principles. But in any event, Larry Sullivan and I felt that the principles were still too rigid, and we wrote what was essentially a dissenting opinion in the context of the whole report to say we would like something simpler, related very much to the trade antitrust interface, that there should be a restriction against cartels, including export cartels, that one should think about moderating the anti-dumping rules, and that one should think about simple rules as a general framework for competition. That report was very badly received at the OECD. It was basically slapped down, and it was characterized as much more rigid than it is, and was thrown off the table.
Has it had any impact, do you think, in thinking about antitrust globally?
It has, and much more in Europe. It has some very interesting, important parts about structures of thinking about coherence, drawn from both the European community and from some structures in intellectual property. And they basically are based on non-parochialism. So to prevent nationalism and to have a broad view of the market with a kind of cosmopolitan view, there's much in that report that is very useful and ought to have a life.
Just tell us a little about another committee you served on a few years after that involving global policy, this time from a United States perspective.
Yes, I served on the Clinton committee called ICPAC, the International Committee on Competition and Policy Review, to report to the Attorney General and Assistant Attorney General. Attorney General was then Janet Reno. Assistant Attorney General was Joel Klein. This report was done very much in view of globalization and multitude of agencies in the world. On this report, we had several parts. We looked at better coordination among the agencies of the world in cartels and in mergers. I think the report has some very helpful suggestions in both areas, and in mergers it has a lot of foresightful proposals about all of the agencies in the world that are interested in and vetting the same mergers, having teams of people working together so that there will be more harmonization. It has one other very important recommendation, and that recommendation was adopted and is very much alive. It recommended, with a different terminology, the International Competition Network.
ICN.
Which is now ICN. It recommended ICN in view of the following. There had been a lot of conversation about whether there should be a global antitrust regime within the WTO. This was very much opposed by the United States, or perhaps you should say United States was very skeptical about it, and Joel Klein himself being very skeptical about it.
He was then the Assistant Attorney General.
He was then the Assistant Attorney General. We were thinking that apart from such a scheme, what really would be important, what would fill this gap? There was obviously a really big gap, an incoherence in competition policy and law from nation to nation. So we decided that there was a very important place for a very grassroots effort that would be competition people only rather than trade and competition people. In the WTO, the trade person always had the first seat. The competition person would have a second seat. That was a problem. We thought that competition people alone, getting together and trying to resolve, think about, learn more about differences, and resolve some of them that could be resolved. So that, of course, is now called the low-hanging fruit solution. And that was where that's where ICN went first, to pick the low-hanging fruit and to have rules that everybody would agree to, because there was nobody with an interest in reinventing the wheel, such as the date on which you can make your merger filing. That was the first low-hanging fruit. And so ICN, the members of ICN were really, and I think are, very pleased that ICN has a real life and a real important future in trying both to see where there are convergences and see where there are differences, trying to understand one another's cultures, and move antitrust towards a more coherent system in the absence of international law.
When you first went into academics, my recollection is there were perhaps 30 nations that had some form of antitrust law. Do you have a sense of how many nations today have antitrust regimes?
There are 100 today. It really has been a great swelling of antitrust. And this leaves us with now the big antitrust family, which is very useful. I think in antitrust that our ideas about coordination, cooperation, building bridges are more advanced than in almost any other field. And I also think that there's a factor very important in this. Most antitrust lawyers are adamantly anti-parochial. When you think about markets and antitrust, we have no thought of trying to keep out the Japanese or the Germans. We want the markets to work. So antitrust lawyers tend to have this cosmopolitan perspective. And then when you bring them together in this network, it's supporting, it's helpful, it's very supporting of countries who are new antitrust jurisdictions and who have to face governments that may want nationalism. ICN is a support for the cosmopolitan view of markets.
What led you to become more interested in international antitrust and especially European antitrust law in this period?
Yes, shortly after I came to NYU, the world antitrust started to emerge. It wasn't until I came to NYU, because when I was practicing at Simpson Thacher and Bartlett, problems were really national problems. So it was in those periods of years, beginning in the late 1970s and into the 80s. And of course, I always think of one major point is 1989 with the fall of the Berlin Wall. But of course, another major point, if you go back further, is in Europe. In Europe, they adopted the European Treaty of Rome Economic Community in 1957, going into effect in 1958. It was lying dormant the antitrust part was lying dormant for a couple of years until they got enforcement legislation. And they started their enforcement regime rather slowly in the 1960s. But by the mid-1970s, just when I had become an academic, they started to ask me to come over to lecture. They were interested in seeing what we were doing. Barry Hawk also was going over to lecture, and Barry spent a sabbatical year in Europe in the early 1980s. So when my first sabbatical came, Barry said, "Eleanor, you've got to go to Brussels, where the European enforcement is, and I'll introduce you to the people, and you've got to go and learn, and it will open your eyes." So I went to Brussels for the first time ever in 1984 and worked as a visiting expert at the Commission and at legal service for the Commission. That's like the lawyers for the Commission. I learned a lot. I began to appreciate the extent of the relationship of the competition to the whole enterprise that was the European enterprise. And that means the constitutional and administrative framework of the European Union.
At this time, I remember there weren't that many people in U.S. antitrust who were interested in European antitrust developments and who didn't think that Europe had particularly much to teach the United States. Why were you not among them? Why were European developments something that you thought was worth focusing on?
Well, first of all, I had intellectual interest. I had interest in the culture, and I found extremely interesting the relationship of the constitutional structure and the free movement in the internal market with antitrust. That just separately interested me. I want to come back to your thought that most Americans weren't interested, and often when they were interested, they were very negative. I think you might have been suggesting that. In my view, most Americans didn't think about other people's antitrust, and certainly not European Union antitrust, until our ox was gored. And that was Boeing McDonnell Douglas, and a bit later, GE Honeywell. And that woke up America to the fact that there is European Union antitrust. United States, of course, you know very well from your experience in the Justice Department that, and reading, etc., that United States always was free to apply our law internationally whenever we thought something would hurt us. But now the tables had turned, and we realized that other people might want to adopt that principle, and that the world was shrinking, and that conflicts would arise more and more. So Americans then became interested in antitrust, but many defensively rather than sympathetically.
Well, you were ahead of your time. Your interest, I think, initially outside the United States focused on Europe, but then, as you were saying, the world interest in antitrust expanded globally. Your interests expanded to other nations. And I understand that you teach and consult and lecture outside of the United States a lot. I think one of your first activities involved the tearing down of the Berlin Wall, the aftermath, and the role that antitrust was playing in trying to bring democracies to the Eastern European states. Tell us a little about that.
Yes. There was this wonderful period right after 1989 when the Russian communist countries forsook communism and realized that it repressed both civil liberties and economic well-being, that it had promised so much. It had promised to deliver so much economically to make people better off, and people were very badly off economically. So I love to think about that fit, that markets really help people. And also, since I had some expertise, I was invited by many countries to come and talk and listen and learn about the new agencies. For example, the Polish agency, Anna Fernauczyk was then in charge of the Polish agency for its first 5 years. I found it extremely interesting and rewarding to try to help, if I could help, and to try to learn.
I seem to recall about 10 years ago you went to Indonesia and did some work there. What was that about?
Yes, there was a very interesting project that Merit Jano was significantly involved in and got me on board on this project on governance, securities law, markets, and trade, competition and trade. So I was the competition law person on this team. And we went to Indonesia a few times doing a project that Indonesia wanted on how to make markets work better for Indonesia. And I then met many people there and heard about their problems and tried to advise on competition law there. And learned many of the deep issues, such as the issues about ethnic minorities who held the biggest dominant firms, and they claimed that the law was discriminatory against them. The political currents of power, non-power, were very much in play there, and probably are still.
Did they have an antitrust law when you were there?
Yes, they had a new antitrust law.
You contributed to a textbook about EU law 15 years ago, and I understand that you have a new competition law, European competition law book that's coming out this week. Is that right?
Yes, that is right. I'm a co-author on the casebook on European Union law with George Berman, Bill Davey, and Roger Goebel. This was actually an important event in my life when they came to me and said they were writing this book and they wanted me to do the competition part of the book. And that is one of the ways in which I got familiar with the whole body of EU law. So I wrote the competition part of the book, and I now have a new book coming out this week, which is the competition law of the European Union. And in its germ, it's based on the part that I wrote in the Berman et al. Book, but it's very much now standing on its own and relating the competition law of Europe to the whole body of law in Europe and the various aspects that fit together in such a coherent way, including, as you know, the restrictions on state trade restraining action that is a complement to the private competition restraining action.
And something I suspect we'll see a lot of in the response to the global economic crisis. I know and find admirable and fascinating that you're increasingly concerned about the impact of competition and of globalization on poverty and on the underclasses in less developed countries. Tell us a little about that interest.
Yes, I have become very interested in issues of globalization, markets, and poverty. And this in connection with some of the streams of thought that have come up in the successive WTO meetings, the protests against the WTO, the claims that world trade is hurting the poor. And I wanted to try to understand better the relationship of opening world markets and the poor countries. So I also independently sometimes go to some of the poorer countries and try to give the best advice I can on how to do things.
Do you think this ought to be an increasing matter of attention for antitrust lawyers in how antitrust can be helpful in poor countries?
I don't know about for all antitrust lawyers, but I just want to say a word more about markets, globalization, and poverty. And that is to say, globalization tears down barriers. It's basically liberalizing. And there's one thread and theory that liberalization is the most important thing and that everybody is better off. And that is what I wanted to investigate more in terms of the poorer countries, partially because in view of the antitrust element, these countries also often have antitrust law, and partially because the IMF has required it as a condition to getting money. So they find they have antitrust law, and developed nations are often saying, well, this is the one way to do it, and converge to us. And I wanted to explore more about countries and context and what helps countries and what helps poor countries. So I feel pretty satisfied now that certainly globalization helps everybody, not really everybody, in an aggregate sense, and it gives many people opportunities. It doesn't always give the poorest opportunities, especially when they lack infrastructure and they're in very poor states and they lack good governance. My own investigations lead me to think that there are ways in which antitrust laws should be modified and different for developing countries, and that especially the poorest developing countries should first of all follow an agenda for what is good for growth and development. And often the antitrust principle will be the same, but sometimes it is not the same, and the thinking must first be in terms of their efficient growth and development.
You received an honorary doctorate degree 2 weeks ago from the University of Paris in Dauphine. Congratulations for that. What was the degree awarded for?
Thank you. It was awarded for my work on globalization and antitrust, and for my work on comparative antitrust, and as they put it, my respect for the various systems, taking on board what I am learning and finding, and my non-judgmental attempts to understand them and their cultures and what they want to do and then think about law as fitting with what they find is good for them.
We talked earlier about antitrust law before the Reagan administration. What has happened that you think is significant in U.S. antitrust in the last decade, good or bad?
Well, in the last decade, there has been continuingly strong anti-cartel enforcement, and I think that is very good, and I think it's very necessary for the whole world, obviously including the developing world. I am disappointed in other aspects of antitrust law. I think it's been shrinking and shrinking in the United States, and I think that it has been shrinking because of a premise with which I do not agree, and that is, in my view, an excessive faith that markets will work and that companies, even if they look dominant, really don't have power or won't be able to keep power. So that has shrunk our monopoly law and even our merger law. And I think that we've made many mistakes in letting through too many mergers and not caring about abusive acts.
Do you see a relationship between the current economic crisis we're in and the more limited antitrust enforcement you speak of that we've seen with the current Supreme Court?
I think there is a relationship. And let me start with Alan Greenspan and his mentor, Ayn Rand. Alan Greenspan was applying a model pretty much like I just described. The market will work. People have the incentives to make it work. You should see that they have the right incentives, but don't spend a whole lot of time on it because they probably do have the incentives, so the market will work. I think that was the downfall of us. I think that is what led into the crisis. We did not have sufficient regulation. We let firms do too many things, taking on too much risk, and decided not to regulate the conduct on the ground that the market will work. Well, it's the same underlying perspective that underlays our majority Supreme Court antitrust decisions today. I think Alan Greenspan said, "I'm shocked, my model must be flawed," but he was shocked. I don't think that the members of our Supreme Court who have taken our antitrust, shrunken our antitrust, are yet shocked, but perhaps they ought to consider that the very, very free market premises are not representing reality.
As Lenin asked rhetorically a long time ago, what do you think what is to be done?
What is to be done in antitrust?
In antitrust.
We are in a new era, and we have good enforcers in place or almost soon to be in place. And I do believe that the new antitrust enforcers will take a more realistic view of markets, and that will be on a much better and healthier track, and that we must recognize one thing, that the word efficiency has been overused, and it has been used in a way that actually does not help us get to efficiency. And I think for a second thing, and related, that the new enforcers are likely to take more account of ease of entry and access, and keeping the market working as the best way to get to efficiency, because nobody can mastermind efficiency. They have to deal with two really hard things. One is the framework the Supreme Court has laid out in the last 6 years, and the financial crisis, which is unfortunately causing, I think, a popular impression that antitrust is luxury. As Neelie Kroes said, the commissioner in charge of competition in the European Union, that antitrust is a solution, not a cause.
Tell us something to shift gears personally about your life today.
Well, I am very lucky. I have a wonderful life. I have a wonderful partner, Jerome Bruner, who has done so much for education in this country.
He was one of the originators of the Head Start program, wasn't he?
He did. He was an originator of Head Start. He was an originator of the cognitive revolution way back, thinking about how mind is related to culture and not an isolated entity based only on Pavlovian responses. And I have wonderful children and grandchildren, all of whom give me great joy. I also have a wonderful sister, Barbara, and my family is very enriching to me. My students are always enriching to me. I love my students. And I love new students that I meet every day, and often even abroad when I have graduate students taking me around China or other places. I enjoy that. I enjoy the interpersonal relations. And I try to do what little bit of help I can if something that I know can be of help to others.
With all the traveling that you do, what do you like to do when you have time off, when you're abroad?
I don't have a huge amount of time off, but what I like to do is I like to walk in city streets and see the people. I like to talk to people. I like to read. I like to read novels about the place I'm traveling in. But I like to work abroad. I like the contacts and the conversations that I will have. For example, last year I went to Cairo to do technical assistance at the competition agency and was with Mona Yassin, who is the head of the agency, and met her wonderful staff there and met legislators there. And to me, work and leisure are not separated by any bright line.
I know that Giuliano Amato, who was the prime minister twice of the Republic of Italy, and also a leader in antitrust in Italy, gave you the name of appassionata della concorrenza, the passion of antitrust. Besides your children, your family, your accomplishments as a lawyer, you're being a pathbreaker for women in the law, and your personal role in helping to expand antitrust globally. Of what are you most proud?
I wouldn't say I'm exactly proud. I don't have much pride except for my children and family. What satisfies me is, I guess, that my career has been way beyond what I ever thought about and expected because of the low expectations for women. I mean, women were not allowed to do most things. So I had no idea that I would be able to be part of this. I feel very engaged in the broader community. And so there's a sense, there's kind of both a global sense and a very local sense. And I've had a great life and look forward to doing many things. And I'm very grateful for my family and for my friends, including you and Erica, and my work, and my thoughts, and my writing. And I hope to do a lot more writing.
If you were graduating from college today, do you think you would have gone to law school?
If I knew what law school and law was, and if I knew the opportunities it holds, yes.
And in law school, do you think you still might have been attracted today to antitrust?
Oh, I would be very attracted today, to antitrust. But I have to say that antitrust happened to me. I didn't even choose it. This was the fate of women in my age, that we didn't choose very much. We let things happen to them. So antitrust happened to me because at Simpson Thacher and Bartlett they gave me antitrust cases. And I'm so grateful for that. I wouldn't have known how wonderful it could be.
Do you have anything that you want to add after we've discussed this tour of the horizon?
No, I think we'll leave the tour where you have stopped it temporarily for this moment, and thank you very much.
Thank you, Eleanor.